record, Your Honor.
Okay, we're back on the record in Horodesky versus Johnson. So everybody, I believe, is present again. Okay. So during the break, I read Rolfing again and Mayola versus the State of Nevada, which is 99 P 3rd 227 2004 case. And I think there is a distinction in Rolfing. Rolfing.
Can you repeat that site, Your Honor? I'm sorry, I didn't catch it.
I'm sorry, what? Oh, the site? It
99.
is 99 P 3rd 227. It's a 2004 case, and the name is Mayola. M as in Michael. Aiola. And that is the case that is the negative treatment of the Rolfing case. So it cites to the Rolfing case. So I just wanted to say if it said anything that would change my mind, and
You can have that.
but it didn't. So looking at Rolfing again, just double checking my understanding of Rolfing. The facts were a bit convoluted, but in the Rolfing case, there was one judge that was sitting in a trial, Judge Gwynnon, and Judge Gwynnon granted in a criminal case, and Judge Gwynnon granted the state's motion for a mistrial, and the defense objected to the mistrial, and then subsequently the state filed to reset the case for trial again, and the defendant, Rolfing, filed a motion to dismiss the criminal charges pending against him, and the motion to dismiss was heard by a different judge because of the rotating criminal calendar in the 2nd Judicial District Court. So the motion to dismiss was heard by Judge McGee, and Judge McGee granted the motion to dismiss. So Judge McGee did not sit in review in particular of Judge Gwynnon's decision, but and the court noted that neither party objected to that process, and then the state did not appeal the order granting the motion to dismiss. However, shortly thereafter, Judge Gwynnon, the first judge, he entered an order declaring void Judge McGee's order granting the motion to dismiss, which meant that Rolfing was going to have to stand trial again for his charges. And Rolfing responded by filing a motion to vacate Judge Gwynnon's order, and the state opposed that motion, and during the pendency of that motion, the state filed in the district court a motion to set the case for trial, and then a different judge denied that motion. Then subsequently, Rolfing's motion to vacate was heard by Judge Gwynnon's successor in office, the Honorable Brent T. Adams, and Judge Adams denied the motion after hearing extensive arguments. So nobody argued or found that it was inappropriate for Judge Adams, who was Judge Gwynnon's successor in office, to hear Rolfing's motion to vacate. The problem that the Supreme Court had was that Judge Gwynnon entered an order declaring Judge McGee's order granting the motion to dismiss. Wait, did I say that right? The problem the Nevada Supreme Court had is they said that Judge Gwynon's order declaring void Judge McGee's order granting the motion to dismiss was inappropriate. So that's where they are saying that a judge cannot, that ordinarily one district judge lacks jurisdiction to review the acts of other district courts. So I take this decision to mean that I couldn't walk into Judge Duckworth's courtroom and make a decision on one of his cases unless I was a senior judge, filling in for him on a day or something, or as in this case, the Horodesky case, unless I was administratively reassigned the case, as is what happened in the Horodesky case. I am in the position to take over, and I am bound by Judge Forsberg's decisions unless there's a motion for reconsideration, and that's why we have the rules allowing for reconsiderations of motions. And so I do believe that I am authorized to review the case that she filed. So I believe jurisdiction is appropriate.
The second question then would be, Your Honor, if you are going to review it, what review standard is going to be applied? Is it a de novo review? Is it going to be a clearly erroneous standard? What legal standards is the court going to apply in reviewing her decision?
Ms. Robinson?
I have not had to argue standards of review in so long, Your Honor. I don't know, under our motion for reconsideration.
Motions, reconsideration 5.51 is EDCR 5.513. And it says, it doesn't say, it just talks about the timing of it. It doesn't say what the standard of review is. So don't tell me that now you want to have another hearing and have everybody brief the issue on the standard for motions for reconsideration.
I am really concerned about the jurisdictional aspect of it. I think that reviewing another sitting district court judge's order and trying to put yourself in the place of that judge, I don't know of any case law that would allow a judge to completely reconsider a judge that has the same amount of power under the Constitution. If it's going to happen, I would just ask the court to set forth a clear review standard so that, if my client's going to do a writ or if he wants to address it, I can sit down and talk to him. I mean, I don't know is the bottom line. I've never seen a case that allows a judge to review another judge's order the way that we're proceeding.
Well, we may need some case law in that regard. I don't know. But I'm very comfortable with the jurisdiction, especially after reading Rolfing and this Mayola case, because nobody had any problems with well, anyways, I don't need to get back into that. I already said.
Well, and Judge, just so we're clear, nobody appealed any of that. The issue on appeal was whether a judge had the authority and the jurisdiction to review another judge's decision, and the Supreme Court's order is 100% unclear. It says that the court lacks jurisdiction to reconsider, to vacate another judge's order.
Well, and
right. I agree with all of that, Mike. You're correct in all of that, but the district court rule does allow our judge to look at this. in that case, and what Your Honor pointed out was there was no motion pending. It was a sua sponte order by that judge. He just went in and made his ruling. And so that's what was appealed, and that's what the Supreme Court is saying was wrong, because he had gone in and totally vacated a prior order, and there was no motion pending. But here, one, we have an administrative reassignment, and two, there is a motion pending. There's a motion pending for reconsideration. So it's not like Judge Mercer's going in and making up new rules and vacating Judge Forsberg or anything. She's ruling on the motion for reconsideration that's proper under her jurisdiction.
Yeah, and I'm reading the Supreme Court's holding as much more broad. It says the district courts of the state have equal and coextensive jurisdiction. The district courts lack jurisdiction to review the acts of other district courts. Obviously, you've issued your ruling. I just would like some clarification as to how the court intends to review Judge Forsberg's decision. It's kind of funny, Your Honor, because I'm on the Rules Committee, and we in the rewrite of the rules, we specifically talked about the need for a remand provision in the EDCRs, but we never got around to actually passing it for the rule rewrites. So I don't know.
What do you mean by that? Need for a remand? What do you mean?
Well,
by that?
in a perfect world, Your Honor, since the case has been reassigned to you, it would be nice for the local rules to give you the power to remand it to the judge to hear the argument.
Oh yeah.
And it seems to be something that it's just been missed. Hopefully, it will be addressed in the next rule rewrite.
Yeah, and I think I told you guys in the last hearing that I actually did. My JEA reached out to Judge Forsberg's JEA, about that, to have her review it, and she declined and said her understanding of the rules is that I have to sit and reconsider her decision. And like I said, it's come up. I can't count the number of times it's come up since I've taken over. Since the cases have been assigned to me from tons of different departments, not tons of different departments, but all of the other different departments. And now and everybody takes that as an opportunity to get a second bite at the apple. And I keep getting lots of motions for reconsideration of prior judges' rulings. So it is a problem. It is an issue. And I totally understand your concern. But I disagree with you about the jurisdictional authority. I believe that I absolutely have jurisdictional authority to sit and review, but I agree with you. It's difficult for me to know, what her thought processes were. I can only go by the four corners of the case and look at everything that was filed and the transcripts and make a ruling. As far as the standard of review for reconsideration, is there a rule in our CP? I'm having a lack of my comprehension, my memory. In the NRCP, I just looked at the EDCR regarding motions for rehearing, a reconsideration. But is there a motion? Let's see.
It's NRCP 52, Your Honor.
Which one is it?
52.
52. Thank you. I could not remember. I don't see it.
It would look, I think she's referring to 52.6, which says findings of fact, whether based on oral or other evidence, must not be set aside unless clearly erroneous, and the reviewing court must give due regard to the trial court's opportunity to judge the witness's credibility. Is that what you're referring to, or Ms. Robinson?
I thought we were looking for an NRCP
Reconsideration.
rule that addressed motions for reconsideration.
Well, NRCP 52 does deal with setting aside the prior findings of the court, and that is the standard that NRCP 52 adopts. The problem is, though, it would leave you in a position where you have to defer to Judge Forsberg's decisions on credibility on facts.
So we never had there was never any evidentiary hearing.
Yeah, there wasn't an
for
evidentiary
findings of
hearing. It
fact.
was just a motion hearing, and I do have the transcript.
She actually took she took testimony from Lynn Conant. She obviously accepted the child interview report as evidence. I disagree that there was no evidence considered by the judge.
Well, there wasn't an evidentiary hearing per se, but it did have some components of that, as you said.
Yeah, Lynn wasn't there that day, Your Honor. Lynn was there, I don't know. I want to say at least 6 months prior to that.
She was
Did we have
there,
a year
let's
before
see,
that?
she was there at the June 18, 2019 hearing.
That's really the last time any of us dealt with her,
Yeah,
and she was a no-show to that. So, and Bree Mullen, Dr. Bree Mullen didn't, even come, and so I mean, not sure what she based her findings on exactly. It was unclear.
but in this this rule that you've pointed out, NRCP 52 A6, setting aside the findings, it even implicitly allows for a reviewing court to hear cases. Findings of fact, whether based on oral or other evidence, must not be set aside unless clearly erroneous, and the reviewing court must give due regard to the trial court's opportunity to judge the witness's credibility. But again, it looks like this rule is talking about an action that has proceeded to trial.
I don't know where else that rule would be other than the one already mentioned in the EDCR.
Mm-hmm.
The court understands I'm not arguing with the court. I just want some clear idea where we're going.
Yeah, it's okay. It's even okay if you argue with the court. I got thick skin. We all want the right result. I just ran a little quick search here. I don't know how y'all feel about this, but I wouldn't mind taking a look at some of these cases that just came up for standard of review on reconsiderations. Looks like there might be something in here.
I can say I've honestly never had that question posed before.
That's a good question.
Mm-hmm.
And understand in asking the question, I don't know what the answer is either. It's it's easy with an appellate court. I know with the appellate court, obviously the findings of fact, it's a clearly erroneous standard. The application of the law would be a de novo standard. But obviously that's an appellate court. It's a different posture.
What does the name say there?
Angel Mora.
Mr. Mora, are you here? What?
My bad.
What case are
Wrong
you
court.
here?
Oh, the joys of online hearing.
Oh my gosh, you have no idea. It's just, jeez, this whole, yeah, that's another conversation. I would like to explore this further, but gosh, I don't want to keep you guys in limbo. But I would like to explore this further. It looks like the answer is probably in here, but it's just not popping out at me. No, I'm gonna need to look at it. Are y'all looking too while we're talking?
Yeah, I'm doing the same thing you're doing, I think.
Ms. Robinson doesn't look like she's researching.
She probably has it all stored in her head. She doesn't need to.
She's waiting. She's lying in wait. No, that's a joke for the record. Well, yeah, I just need a little bit more time.
Can I ask a question of Ms. Robinson?
Sure.
Kind of unusual. What if the district court stayed the proceedings and your client presented this to the Supreme Court as a solution to this? Would that matter?
I think I need to make a decision that you guys can,
Okay.
that you can appeal or that you can file a writ. What do you think, Ms. Robinson?
Agreed, yeah.
Can we go off the record and let me look at a little bit more stuff, or do you want?
Yeah, and the other potential standard of review might be in Rule 59, grounds for new trial or amendment of judgment. 59A1.
Let me look.
Like, nothing clearly fits, but Or Rule 60B.
I don't see anything in 59 that would work.
59A1, grounds for a new trial. The district court may grant a new trial on all or some of the issues to any party for any of the causes.
Yeah, that doesn't talk about standard of review. And that's for a new
Okay.
trial. Is that trial on for tomorrow?
Let's see.
Is that a full day?
I just show matter continued from day 2 of trial, matter continued.
What? You mean it's still going forward tomorrow, right?
Yes. But the one on 7/7 was a half day.
7/7
Yeah, it started on a half day.
is a Saturday.
Well, we were here.
No. I mean 8/7. 8/7 is a Saturday.
Mm-hmm. No, I'm saying when the day 1 of trial was 7/7, and that was a half day. So I'm not sure if this one is going to be a whole day.
All right. I just need a little bit more time, y'all.
Understand, and obviously to give us time to see if we can figure it out as well.
Yeah. So I'm trying to figure out if y'all can come back tomorrow. I have a trial in the morning at 9, but I might have the afternoon free. Trying to find out.
You know, I actually, I could probably reschedule, actually. I have a 1 o'clock and a 2:30, but it looks like they're both in office.
You know what? I don't know if it's well, I think it's a half day. Are y'all able to come back tomorrow? Afternoon?
What time, Your Honor?
Let's say either 2 o'clock or 3 o'clock would be better. 3 o'clock.
Is there any chance it could be pushed to 3:30, or is that too late
No,
for Your Honor?
3:30 is fine. Does that work for you, Ms. Robinson?
Thank you, Your Honor.
Can we come back tomorrow at 3:30? I'm going to do some research. All right. Let's do that. Okay. Good. So I'll see y'all tomorrow at 3:30, yeah?
All right.
Very good. Thank you, everybody. Okay, we're adjourned.